would like to seek your lordship indulgence in mentioning item number 9 and 10 from the hearing list.
Item number
9 and 10.
9 and 10, yes.
Your lordship, we have taken consent from the other parties, so if this matter may kindly come up after 2 weeks.
Your name?
Febi Ilrindungi, my lord.
MS so-and-so, learned counsel, appearing for the appellant with consent from the other side, seeks accommodation in the matter on the ground.
The leading counsel, Mr. Malhotra,
On the
seems to have
ground that
personal
Mr. A.R.
issues.
Malhotra, the arguing counsel, is
Mr. Malhotra,
having what? Personal difficulty?
personal difficulties.
Is having personal difficulty today. Relist on, yes, when?
After 2 weeks.
Released after a week on a date to be fixed by the registry. Yes, next.
Oblige.
Made please, Your Lordship, Madam. And I beg to mention listing of an unlisted matter, Madam. I beg to mention a listing of an unlisted matter.
Unlisted.
Madam, criminal petition, Madam. Here, Madam, what happened, Madam? The complaint petition has been filed against the petitioner for defreezing his account, whereas the for defreezing the account of the complainant, whereas the defreezing was done on the instruction of the police in Delhi and also in the court in Delhi, my lord. So now the
Unlisted you wanted today.
my lord, the matter is fixed tomorrow, my lord, for appearance. But there has been suppression of facts in the complaint petition, but there is some urgency, my lord. There has been vital suppression of facts in the complaint petition because the petitioners have been impleaded on their person.
Appear.
My lord,
You appear.
will appear one, but before, my lord, if your lordship allows us to place the facts, my lord.
You are the accused.
I am the accused impleaded personally, whereas, my lord, the instruction was
Impleaded in when? Where? In that complaint
in
case?
the complaint case as an accused. But I am the
Then
class.
what is the urgency?
The matter is fixed tomorrow for appearances and the
You
taking.
appear. Monday.
Then tomorrow, my lord, the matter may fix
You
tomorrow.
file it, it will come on its own.
My lord,
You file it, it will come.
my lord. Oblige, my lord.
For admission, item number 1.
My lord, this matter is taken up by Miss Mary,
Yes.
and my lord, she has some personal difficulties today.
All right. Monday then.
Yes, madam.
Monday.
My lord,
Ms. Mary, since last 2 days is having some medical problem. So,
my lord, this afternoon I will be taking off due to my.
sorry.
This evening, my lord, I will be taking off for my medical.
When do
checkup.
you want?
After 2 weeks, if possible.
All right. This matter was fixed today
Yes, my lord.
for placing before the court the instruction which was called for by order dated 13/5/2025, which on 16/5/2025 was informed before this court that though the state counsel, though the learned counsel appearing for the state respondents, contemner, has received the said instruction, however, the same is in vernacular language. And today the matter was posted for placing the translated instruction. However, today when the matter is called, a mention is sought on behalf of MS Mary so-and-so, learned counsel for the contemners on medical grounds. When are you coming back?
After 2 weeks.
Mr. so-and-so, learned counsel for the petitioner, seeks posting the matter after 2 weeks, as he is also going to be out of station from today.
This evening, yes, ma'am.
From today onward, from today afternoon. Stop. In view of the above, relist after 2 weeks on a date to be fixed by the registry. It is needless to be clarified that on the next date of listing, the instructions as sought for by this court by orders dated 13/5/2025 and 16/5/2025 shall be placed positively before this court, failing which, if required, personal appearance for the hearing officers shall be considered.
Item number 2.
My lord, similar prayer in this matter.
Who is R15?
The deputy commissioner.
The Deputy Commissioner was supposed to file a counter affidavit.
Yes,
Yes, my lord.
I
What
believe
happened
Your
to the
Lordship has
counter
filed a
affidavit?
counter affidavit.
Counter affidavit filed.
Yes, Lordship.
All right. If it is filed, it's okay. Miss Mary is appearing in this matter
Yes, my lord.
next week.
Your Lordship, I believe there is no more urgency. In this case, she stated that a word was made and due to some miscalculation, reassessment has to be done. So it may be taken up after 2 weeks.
Okay.
And the
A
developments. will be-
mention is being made on behalf of MS Mary so-and-so, learned counsel, appearing for the respondent number, contender number.
4, 8, 10, 13, and 15.
Please give the numbers. Respondent stroke contender number so-and-so. Prayer is not opposed. Relist after 2 weeks on a date to be fixed by the registry.
Item 3.
My lord, in this matter,
Miss Linda was supposed to file an affidavit.
yes, my lord, but I have received communications from the revenue department stating that this honorable court order dated 6/2/2023 in WPC 50 has already complied with.
Complied.
Yes, my lord.
Is it complied?
My lord,
I can close it.
my lord.
Okay. Heard MS Valentina Lanenpui, learned counsel for the petitioner.
My lord.
Also heard MS
HCC Deborah.
so-and-so Deborah, learned counsel, appearing on behalf of the contender number 8.
Yes, my lord.
8, right?
Yes, my
You are
lord.
on behalf of Miss Linda, isn't it?
Yes, my lord.
On behalf of contender number 8, who submits that, no, full stop, so-and-so Deborah, learned counsel, submits that in terms of the, yes, give me the instruction.
My lord,
So you said you have
Yes,
received
my lord,
instruction, where is it?
I have give it to the court master.
Where is the instruction? You have a copy?
July.
Why are you keeping it there? Why are you not giving it here? She submits, so-and-so submits the communication received from the Undersecretary to the Government of Mizoram dated 30/7/2024. Informing the Office of the Additional Advocate General, Government of Mizoram, that upon joint verification in compliance of the direction of this court order dated 6/2/2023, it was found that there is no encroachment of the petitioner's land by the Home Police Department, but all the petitioners are rather the encroachers of Department Land Lease DPL number 195 of 1908, and therefore the petitioner's lands are liable to be cancelled after serving show cause notice in accordance with law. It is further informed that in view of the fact that the petitioners have been encroaching on government land, no further action in terms of the no further action in terms of the court's order dated 6/6/2023 is required. Stop. Copy of so and so along with the minutes of the joint verification along with the minutes of the meeting in connection with joint verification report of Home Department land at Tlang Lunglai underpass number DPL 195 of 1980 in connection with WPC number 50/2022 held on 6/6/23 in the office chamber of Commissioner and Secretary Home Department. Comma, and the joint verification report is kept on record and marked as X. MS Valentina so and so submits that the order of this court, the order of the judgment and order of this court dated 6/2/2023 passed in WPC number 50 of 2022 stands complied. In view of the aforesaid endorsement made by the learned counsels appearing for the both parties, there appears nothing to adjudicate in the contempt petition. Accordingly, the contempt petition stands closed.
My Lord, one rectification I think is required in paragraph number 1. Hence, no further action with respect to the order dated 6/6/2023 should be 6/2/2023.
6/2/2023.
Yes, my Lord.
6/2/2023. Thank you, Ms. Valentina.
My Lord.
Item 4.
Impleadment.
Yes, my lord, as allowed by the honorable court, my lord. If I may be allowed to, I will be filing this implement application during the course of the day.
You are filing?
Yes, my lord.
All right. MS so and so, learned counsel for the contempt for the petitioner. For the petitioner submits that the impleadment that an impleadment application shall be filed within the course of the day. List after 1 week on a date to be fixed by the registry,
Yes,
along with the impleading application, if any, filed.
Obliged.
Item 5.
First time.
Yes, my lord. If I may, your lordship.
It's a regular first appeal.
Yes, my lord.
I'll admit it. It's a
This-
statutory appeal.
Yes, my lord. This is an appeal filed under Order 41,
Yes.
Rule 1.
Heard MS so and so, learned counsel appearing for the appellant. Stop. This appeal is being presented under Order 41, Rule 1 and Section 151 of the CPC 1908, read with Section 47A of the Guwahati and Wards Act 1890.
Guardians and Wards Act. ma'am.
Huh?
Guardians and Wards
Sorry,
Act.
Guardians and Wards Act 1890 against the judgment and order dated 12/3/2025 passed by the Court of Additional District and Session Judge Kolasip, District Kolasip in Guardianship Certificate Case number 2 of 2023. Stop. Admit, issue notice. How many respondents?
One respondent, my lord.
Issue notice, returnable with issue notice with AD card and all that, returnable 2 weeks. Call for the case records from the Court of Additional District and Session Judge, Kolasip District, Kolasip, in so-and-so certificate case number 2 of 2023. Correct?
Yes, my lord.
That's all. Anything else to be called? Only the judgment and the records.
Obliged, my lord.
List after 2 weeks on a date to be, you make it returnable 4 weeks. And list after 4 weeks on a date to be fixed by the registry.
Obliged, my lord.
For order. Item 6.
Yes, Your Lordship.
Mr. Mahajan, you are appearing in this?
My lord, may I please your lordship?
Yes.
My lord, here, my lord, we took the grounds, only, my lord, on the sole grounds, rather, my lord, violation of 47 and 48 BNSS, my lord, and they have filed a rejoinder, and rejoinder may be looked into, my lord, paragraph 6.
Who's appearing for the state?
I'm appearing in Lordship.
State?
Yes, Lordship. Union of India, Lordship.
Oh, Union of India. Yes.
DRI, my lord.
Yes, in affidavit, which page?
My lord, it all page 4, para 6, my lord.
This is a NDPS.
My lord, my lord, my lord.
Para
6, my lord. Page 4, my lord.
Yes.
May I, my lord?
Yes, please.
That with regard to para 5 of the bail application, wherein we took the grounds, my lord, the violation of section 47 and 48 of the BNSS, my lord. The answering opposite party submits that the provisions of section 47 and 48 are very well complied
All right,
with.
where is the copies of arrest memo?
My lord, those are, we have annexed, my lord. To be very precise, my lord, section 35 has been complied with, that is arrest memo. In arrest memo, even if it is provided partially, that is not providing the grounds of arrest, my lord.
Yes.
And in my application, my lord, Lordship may kindly have a look at page 15, my lord.
Where is the arrest memo, Mr. Mahajan?
Page 15, my lord, of my bail application, my lord. Three
Page?
accused through different arrest memos, my lord. 15, 19, it continues, my lord. Same stereotype, my lord.
Yes, page 15.
Page 15, my lord.
You are Sabir Ahmed.
There are 3 accused. One is Sabir Ahmed.
So in this bail petition, there are total 3 petitioners.
My lord, my lord, my lord,
One is Sabir. Yes.
my lord. This is the arrest memo, my lord. And herein it has been provided like this, my lord.
Mr. Mahajan, in fact, you are fortunate that this time at least they have
Yes,
indicated
yes, yes.
everything in the arrest memo.
Yes,
Huh?
my lord. Yes.
Unlike the ones in Guwahati,
My
huh?
lord, my
Those
lord.
are just the format. The
My lordship
notices.
is very correct, my lord.
But this,
But
this,
here, my lord,
this
one thing
arrest
happens,
memo
my
has a
lord.
lot of facts. The offense is also mentioned. Committed an
Yes, yes,
offense
my
under
lord.
section 22C,
Can I come to the other
23C.
section of law, my lord?
Brief facts of the case, seizure of so and so, the seized goods were transported in a
Yes.
used cement so and so. So it is
My
all
lord.
there. The list of the seized so and so
Yes,
were
my lord.
recovered. Now you see that this court cannot go into the sufficiency of these facts.
Lordship is
Yes,
correct.
yes.
Can I just go to
Yes,
the other ground,
and
my lord?
Mr. Mahajan, the other thing is that it appears that it is impersonal. It is not in general also.
No,
It-
no,
it-
no,
It
no,
is
no.
mentioned that tablets from the possession of so and so, so and so,
Mine.
so and so,
Also, yes, yes.
Sabir Ahmed. So it is
Mine.
there.
And
Right.
maybe
Can I-
Lordship,
can
Lordship, at para number 6, it has been clearly stated that I have, at para 6
Para
of this
6
page
of-
15, my learned friend had read out. At
Yes,
paragraph
yes,
number
yes.
6, I have
Been
been
explained the
explained
grounds of
my
arrest,
arrest,
the
the
facts
fact
of my arrest has been
witness.
witnessed by so and so.
We have
And where is
complied
the
with law.
signature?
Signature is in the next page.
Sabir
Lordship.
Ahmed, he signed in
Yes,
English.
Lordship.
Yes.
My lord.
This
My
ground
lordship
is
correct.
not
Lordship-
there in your case, Mr.
No,
Mahajan.
exactly, my lord. That's why I'm coming to
So
48, my lord.
22, you see, let me make it very clear. If there is a violation of 22(1), certainly this court will grant
My
you
lord.
bail immediately. There is
Yes.
no way, no another way. However, if your ground is about statutory violations and non-compliances, I may remind you that there are sufficient decisions of the apex court where it is
Lordship,
clearly
yes.
said that these are matter of trial and it can be only looked into that.
Very
Right
well,
Lordship.
now,
Correct.
I have to go as per the rigor of section 37.
My lord, my lord, my lord. Can I come to
Yes.
the, my lord,
So
lord,
please
lordship, 20
confine your arguments to that.
Exactly, my lord.
Yes.
Here, my lord, it may be partial compliance, but there are authorities that will be debatable, my lord. I'll not go into it, my lord. But here there is, my lord, total violation of section 48. That also flows from article 22(1), my lord. And that has been clarified by Vihan, my lord. May I just read that?
Vihan has
Regarding
to be
from-
understood in the context it is said. It is ultimately under 22(1) because in that case those informations were not there in the notice. It is on that context. But here what is required ultimately is paragraph 21 of Bihan, where
My
it
lord.
has been clearly said that it has to be communicated in such a manner that the person understands it. What is
My
the
lord.
requirement of 22(1) is the information. The person must know The
My lord.
person who has been arrested must know as soon as may be from his arrest. That
My
is
lord.
within 24 hours according to me, because within 24 hours he has to be produced.
Forthwith,
So
my lord.
within,
Yes, my lord.
within that period, he has to
My
be
lord.
communicated, he has to be informed. And
My
that information must be in such a manner that that person can understand that
My
because
lord.
of such and such thing, he has been arrested. Now,
My
some procedural lapses, some formats not being there, I am sorry, I will not go into all that.
Lordship is
Here,
correct.
the arrest memo is in front of me, it is absolutely clear. It's
lord.
absolutely clear.
My lord, my lord. Can I come to the other ground, my lord? With all
Yes,
respect, my lord.
yes,
Yes, my lord.
Yes.
Just 47 we leave aside, my lord.
Yes.
But there are just academic, my lord. Let us
yes,
not
yes,
go
but
into it.
no use, Mr. Mahajan, there are several cases.
Lordship,
47 not at this stage,
I have
37,
understood.
you see, because NDPS Act. Mr.
Your Lordship is
Mahajan,
correct, my lord. Lordship
please-
is correct. I will not
please
go to
read
it. My lord, Lordship is
37
very
once.
correct. Court's time, my lord. Let us come to 48, my lord.
48 of NDPS,
No, 48 of the BNSS, my lord.
BNSS studio.
একটু বলো। জলদি।
Yes,
48 of the BNSS, my lord.
yes,
Earlier it was 51, my lord, now 48, my lord. It's a statutory provision that also flows from Article 22(1), my lord. May I, my lord?
48,
8, my lord, BNS.
yes,
May I, my lord?
yes, please.
Every police officer or other person making any arrest under this Sanghita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relative, friends, or such other person, as may be disclosed or nominated by the arrested person, for the purpose of giving such information, and also to the designated police officer in the district.
Yes,
This has been, my lord, total violation, my lord. This has never been done, my lord. So Article 47, grounds of arrest to the accused,
Article
my lord.
47.
Oh, I'm sorry, my lord. I'm wrong, my lord. Section 40. I'm sorry, my lord. Extremely sorry, my lord. Section 47, my lord. That has been, lordship has said complied with, yes, complied with. But, my lord, that compliance itself will not go as a matter of abundant caution, my lord. The intention of the legislature was very clear. 48 was formulated, my lord,
You know,
flowing from
these
Article
statutory
22(1), my lord.
compliances will not apply, because you see, it is section 37.
Lordship, yes.
My lord.
You see,
My lord,
the rigor
my
of
lord,
section 37 may not
Embargo,
apply
embargo.
when there is a constitutional violation.
but, can I come to
The
that, my lord?
right of informing the relative and friend is not envisaged under Article 22(2), Mr. Mahajan.
Lordship,
My
I
What
may,
is envisaged under Article 22(1)
Yes,
one
yes,
is
yes.
that
Huh?
he must be informed.
My
Yes,
lord,
you
that
want to
has
say
been
something?
clarified
Yes,
by
relative
Jehan, my
has
Just
lord.
one second, yes.
Lordship, information has been given to the relatives.
Oh, it has
Lordship.
been given?
Yes, that is in page 15 in that arrest memo. It has been clearly stated, Lordship.
Page
Page
15 only.
15.
Yes,
page
where,
15.
where?
At Lordship, paragraph number 4.
Yes,
This intelligence officer such and being duly authorized arrest at such and such, and at 5 accordingly Sabir Ahmed, son of such and such, has been placed under arrest and has been explained the grounds of arrest. He was also informed about
where
his
are
right
you
to have
reading? I
someone.
don't find it here.
Page 15, Your Lordship, of the bail application.
Okay. He has been
paragraph.
explained the grounds of his arrest. He was also informed about his right to have someone informed.
About.
And so his wife. Yes.
Has been informed
Yes,
about
yes,
his arrest
yes.
through mobile phone, Your Lordship.
Yes,
We have
yes,
complied with.
Yes.
Very much complied.
I
My
mean,
lord,
what is
my
the
lord, my lord.
quantity?
Quantity is
My lord,
Lordship, commercial
my lord.
quantity, Your
Yes,
Lordship.
how much?
Lordship, that is so
So
Some
possession
seven,
is already
7872, Your
established.
Lordship.
Huh?
7872 grams.
7872.
872 grams. Yes, Your Lordship.
Sorry, Mr.
It's a huge
Mahajan.
quantity, Your Lordship.
Sorry, this is
Can
not.
I,
Sorry,
my
Mr.
lord, I'll
Mahajan.
come to that. I'll come to that, my lord.
37.
Yes,
My
Let's
lord.
have 37.
My lord.
37 NDPS Act.
Yes, my lord. Can I come to Bihan, my lord? It's formulated, my lord, and by
37,
mobile
Mr.
phone.
Mahajan, I have been reading and reading, Vihan.
Yes,
I
ma'am.
shall, for your satisfaction, we'll read it again for an academic
ma'am.
exercise.
Yes,
But
ma'am.
before we
Yes.
go to Bihan, please come to 37.
Yes, my lord, the embargo is there, my
No,
lord.
let's read.
Yes, my lord, yes, my lord, I'll read 37, my lord.
Yes?
NDPS,
Mr.
this is not.
Nimesh, give a copy of
Yes, my lord.
NDPS to Mr. Mahajan.
37. Yes, my lord.
Second part only.
Second part, full, sir, 37 full, good is. 37, my lord.
Yes,
my lord.
Mr. Mahajan, read.
Yes, my lord. Offences to be cognizable and non-bailable. Notwithstanding anything contained in the Code of Criminal Procedure, every offence punishable under this Act, thereafter the proviso 2,
No,
my lord.
Section
Roman 2.
37 of NDPS Act, Mr. Mahajan.
My lord, exactly.
Yes, read.
Section 37, Roman 2, my lord.
Yes. Sorry.
Where the
read.
public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail.
So you see, the test that this court has to apply at this moment is to
Yes.
see whether there are reasonable grounds for believing that the accused is not guilty. This
Exactly.
is the test. Now, when I apply this test, possession is from you. So
My lord.
the test goes against you. Now, if
Okay.
you want to make out a case where Section 37 will not be applicable, then you
Yeah.
must show
Yeah.
that there has been
Yeah.
a violation of Article 22
Yes, exactly.
Yes.
or
Exactly.
21.
That is what second part
But
of
that
the-
is not the case. Vihan Kumar's decision can only come if there is a violation of Article 22. The
Yes, my lord.
arrest
Can I
memo,
read, my lord?
absolutely
Can I-
clear, nothing more than that.
Can I, my lord? The lordship is correct. I'll agree with your lordship's view. Even then, there is a leeway, my lord.
All right.
With all respect.
All right.
All right, my
Vihan
Because,
Kumar.
my lord, the embargo, my lord, the embargo is talked about. And it is exactly. My lord, here first the authority, my lord, Rihan,
Call Amit.
last part, my lord.
अमित को बोलो कि मेरा ड्रॉयर खोलने के लिए वहाँ पे इतने सारे केस लॉस रखा है, लेके आओ. यस,
Second part.
ड्रॉयर खोल के, हाँ.
Last part, my lord.
By any protects of injustice.
Why to go to the last part? Come to 21 first.
It will take.
You want
My
to
lord.
go into the depth? I am here. I
Yeah,
am
yes,
here
my
for you,
lord.
Mr. Mahajan.
My lord.
Let's start
My
from
lord.
21.
Yes, my
Last
lord.
part, last part.
Last part, my lord.
Yes.
Point it
Start
And
from.
petitioner's last part, my lord.
Yes.
There are 2, my lord. May I
Yes.
read, my lord?
Yes.
The issue on the requirement of communication of grounds of arrest to the person arrested, as mandated under Article 22(1) of the Constitution of India, which has also been incorporated in the Prevention of Money Laundering
This is
Act.
Pankaj
Goes-
Bansal. They are referring to Prabir Prakasto and Pankaj Bansal.
Exactly, my lord. Thereafter, my
But
lord,
you
the
see,
parting
Mr.
lines, my
Mahajan,
lord.
before
My
you,
lord.
if you go to Justice Singh's judgment,
My lord.
first the majority judgment, which is the conclusion, come
My
to
lord.
21. You have
My
to
lord.
understand
point,
paragraph
according to
2
Huh?
with para 21. First read
My lord,
21.
on this point, my lord, on coordinated benches, my lord, have granted the privilege, my lord. May I read, just complete the
Okay,
line, my lord,
okay.
if the lordship allows me, my lord. After Pankaj Bansal, my lord. So
Yes.
as to be the state
When were you
constitutional mandate.
arrested? When were you arrested?
I was arrested, my lord, in the last part of November, my lord. 24/11, my lord.
24,
11, my lord.
11 of 23, 24.
4, my lord. 24, my lord.
All right.
May I
Paragraph 2, yes.
May I continue, my
Yes,
lord?
please.
The state constitutional mandate has been incorporated in the statute under section 1050, my lord, of the CRPC, now section 647 of the BNSS. It may also be noted that the aforesaid provision of requirement for communicating the grounds of arrest to be purposeful. Other persons of the accused is also required to be
All right,
communicated.
I have read it, but sorry, I shall not accept the submission. I have read it. I have understood what you wanted to say.
My lord.
Coordinate mention.
And coordinate bench, of course, should I place or not, my lord? I do not know, my lord.
All right, it will, Mr. Mahajan, every case will depend on the facts of each case.
Yes, yes.
As far
my
as
lord.
this case is concerned, I'm fully satisfied that the grounds of arrest has been meaningfully communicated to the accused. That
Meaning that-
being so, there is no violation whatsoever of Article 22.
My lord, can I just, for dilution, my lord, with all respect, my lord, definitely, my lord, 47, Lordship's view, complied with, my lord.
40 also is removed.
But with all respect, my lord, 48,
Relatives also, it has been complied.
no, my lord, regarding that, my lord,
All
by
right.
mobile, if it is given,
Sorry,
that would not be sufficient, possibly, my lord.
sorry,
It has to be in written, my lord. It has to be in written form, my lord.
sorry,
Because
Mr.
there-
Mahajan.
Issue
Eh?
goes to the-
Heard
Can I
Mr.
just read one-
PM Mahajan, learned counsel appearing for the petitioner. Also heard Mr. Johnny L.
Yes.
Tao Chong,
To Chong,
Yes.
learned counsel appearing for the
respondent in lordship.
respondent. The,
My lord, may I just...
sorry,
may I
Mr.
just-
Mahajan,
Coordinate bench, coordinate.
My lord, coordinate bench, one order, can I please? my
you
lord?
can take it to higher forums, Mr.
No, I'm
Mahajan.
not saying that. How I say that?
I am not going
Definitely.
to grant you bail in this matter.
DA 132.
My lord, my lord, can I just read one line of one authority, my lord, of our own High
Mr.
Court, my lord?
Mahajan, I am
My
not with you in this matter. I have
My
been
lord.
reading and rereading these authorities.
My
One
lord,
thing is
definitely, my lord,
absolutely
definitely.
clear, and
My
that
lord.
is that the object and purport of Article 22 and 21 is the basic knowledge.
My
Here
lord, my lord.
he has been communicated. I'm sorry.
My
Uh,
lord.
This is an application under section 483 of the BNSS 2023 seeking grant of regular bail to the accused petitioners I, 1, 2 and 3. You'll get it on page 2, who have been arrested on the same date on
My lord.
14/11/2024.
24/11, my lord.
14/11.
24/11, my lord.
I think it's 14, Mr. Mahajan, at
Yes,
paragraph
1411 in
I'm
lordship,
sorry, I'm sorry,
1411.
my lord. I'm sorry, my lord.
On
I'm sorry,
on
ma'am.
14/11/2024 in connection with DRI Caesar case number 08/CL/METH/DRI-AZL/2024-25 registered under section 22C/23C/29 of the NDPS Act 1985. The brief facts of the prosecution is that paragraph 2 of the petition, Mr. Mahajan, that's
My
the brief
lord.
facts, right?
Only one-
That on 13/11/2024 at approximately 10 p.m.
No.
the intelligence officer of the Directorate of Revenue Intelligence, within bracket DRI, ISOL, intercepted a vehicle bearing registration number AS 24D 2555 within bracket Mahindra XUV 300, black at Boncon, Durtlang Road, Aizawl. It
My
is
lord.
the,
No.
yes?
My lord, sorry, my lord, this is no interruption, my lord, with folded hands. My lord, that last part of Rihan, my lord, last two lines, may I just read it, my lord? In
Yes,
writing,
yes.
it has to be.
Yes.
However, hence the requirement of communicating the grounds of arrest in writing is not only to the arrested person. Sending my mobile on to, my lord, with all respect, my lord. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such a person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal.
On this point, coordinate benches.
On this point, my lord, coordinate benches have several orders, my lord, with us, my lord, Of course, my lord, this is just for academic, my lord. In writing, my lord.
On this point, coordinate bench, NDPS, BA 1321. Thank you.
Mr. Johnny,
Yes.
why don't you clarify this, whether the friends and the, or
It's
his
not been
wife
done.
has been
Not done,
communicated
my
in
lord.
writing or not?
Also, charge sheet has been already
No,
submitted
you find
before the
it
trial
out,
court.
I'm posting it next week.
Wow.
My lord.
Mr. So-and-so,
Well,
Learned
arrest memo is
Council.
too.
My lord, arrest memo, it is there by mobile, my lord.
Charge sheet
You-
complete,
you- you
final charge sheet
check-
is
you check
submitted
this
before the trial
position.
court.
You
also,
check
yes.
this position, I'm giving you the, because this needs to be heard. Mr. Mahajan, Learned Council for
Fine.
the petitioner submits that as per the decision of the Apex Court in Vihan Kumar versus State of Haryana and another reported in 2025 SSC Online Supreme Court 269, it is the requirement, it is the requirement of the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Stop. The word is may.
My lord, my
The
lord.
word is may, Mr. Mahajan.
That is considered shall, my lord, possibly, my lord. Lordship knows more than me, my lord.
It is may.
Coordinate bench to write also.
It's all right. Give them a chance.
Fine.
No problem.
You, per contra, Mr. Johnny so-and-so submits that in this case, submits that in the present case, the arrest memo clearly indicates
Page 15.
clearly indicates that the grounds of arrest have been
My document. It will have some document.
have been informed and communicated not only to the accused but also to his wife.
CPS.
Stop. He further submits that the
Hearing,
arrest
hearing.
memo
Electronic
further
process, hearing.
indicates that the petitioner has also been explained the grounds of his arrest, and he admits the same by putting his signature.
CPS.
He further submits that the requirement of furnishing the grounds of arrest in writing to the friend or relative of the accused is not a mandatory requirement, but shall depend on the facts of each case.
CPS.
Correct?
Yes.
He, however, seeks a short accommodation to further verify from the case records as whether the grounds of arrest has also been communicated in writing to the wife of the accused petitioner.
All CPS.
When do you want it?
My lord, in they are through mobile, my lord. Can that be added, my lord?
Sorry?
In the arrest memo.
Sorry?
In the arrest memo through mobile, my lord.
Huh?
In the, my lord, paragraph page 15, last para, my lord, has been informed
Alright,
about
I
his
am not,
arrest
I am
through
not
mobile.
granting you bail or rejecting you
That's
bail
it, yes.
today, Mr.
My lord.
Mahajan. I have only recorded your submission.
My lord, my lord,
Relist,
my
when
lord.
do you want it, Mr. Mahajan?
Can it be tomorrow, my lord? We'll move out,
No,
my
no,
lord.
not tomorrow. Monday?
Anytime, Your Lordship.
Monday.
Monday, my lord.
Document. Hello.
I
Matlab,
think
can-
that
can one of-
observation will help you, Mr. Johnny,
Yes,
because
yes.
it's May.
May.
I am very sure, but it will need a little more.
All right.
My lord, my
I'll
lord.
do a
Can-
research because
can I-
You research, you assist
yes,
the court.
yes, yes, and final charge sheet is also
Yes.
submitted
You
before the
have a
Nandi
look
trial
at
court.
Probir
Charge sheet is no bar.
and Pankaj Bansal. These two
yes.
cases will help you, and another case subsequent has come, I think, Arora, Ramkishore Arora.
Yes, yes, yes.
My lord,
So,
my lord,
you
my
see,
lord.
ultimately, one or two words can be here and there, but you have to understand what is the intent and purport of Article 21 and 22. These
My lord.
protections are twofold. Firstly, the accused or the arrestee or the detainee, he must know why he is
Arrested.
and this information has to be given to him immediately, not after a delay.
Yes, yes, Lordship.
And secondly, he must be produced before the magistrate within 24 hours of his arrest.
Lordship,
This is the basic right that flows from Article 22(1).
Yes, yes.
And whenever there is a violation of this particular right, no statutory restrictions shall come in the way of stopping this court from granting this person to be released on bail. This is the object.
Very true, Lordship.
This is the very object. Now, as regards the writing in case of informing the friend, in writing may come in when suppose the person has not been given in writing. So it will depend on the facts. You
Yes,
examine
Lordship, yes, yes.
because the
Understand,
word used
Lordship.
is may. It's not shall.
Yeah, it's not
So
shall.
it cannot be mandatory. It will depend on the facts of each case.
Lordship, yes.
But as far as the communication to the accused is concerned, after probir purkasta, that has been decided sometime, I think, in October 2023. Thereafter, it is mandatory that it has to be given in writing
Lordship, yes.
to the accused. This mandatory writing has come after November 2023. Any errors thereafter, without written communication, will go.
Lordship, yes, yes.
So, you assist.
Sure, Lordship, yes.
All right, Mr. Mahajan.
Madam,
Monday.
one line more, my lord. Just a prayer, my lord.
And all
Because
right.
this has been dealt to it. My lord, only this bail application, if it is inserted, it will be better for both.
Call the next.
Item number 8.
My lord, my lord, my lord, my lord, my lord.
Lordship, this is a mic appeal. And by filing this mic appeal, there is a delay of
46 days?
46 days, Your Lordship.
First time.
First time, Lordship, yes.
So issue notice.
Lordship, yes.
All right. You say this is an appeal so and so. You will get it there. And then issue notice. Register steps AD within
Within 3 days, Your Lordship.
3 days. List after 2 weeks.
2 weeks,
On a
Lordship.
date to be fixed by the registry. This is a delay condonation application for filing the connected MAC case. Delay condonation application of condoning delay of 46 days in filing the accompanying MAC appeal.
It's obliged, Lordship.
For hearing, item 11.
This Mary, I think, is not there.
Yes, my lord. The last court, my lord. She almost completed her submission.
Yes, but she's not there today.
sir.
So, but the only thing is that this bench shall not be available next week. This criminal appeal. One second, This criminal appeal was heard in part on 25/2025. MS Mary, learned so and so, appearing for the respondent state, learned APP, appearing for the state respondent, was required to make further submission today, for which the matter has been kept for further hearing. However, today, due to medical ground, she could not be present. She is not available. That being so, release the matter from part heard and list as this bench is not going to be available next week. Relist next week before any other before any available bench.